Hello everyone and welcome back to my channel. Today I want to talk about why a solid operating agreement can protect or save your business from the inadequate default provisions of the New York LLC law. So before I dive into this topic, if you have any questions or you want to set up a consultation, please head to our website, carboneattorneys.com. We have a button in the top right corner of our website. Click it, fill it out, send it over, and we'll get back to you as soon as possible. So, solid operating agreements. How to avoid the default provisions of the New York LLC law. What am I talking about here? Now, for every LLC that is registered in New York State, you must have an operating agreement. What a lot of people end up doing when they register their LLCs is they will download an operating agreement template from the internet, from some website, from a friend, anywhere other than hiring an attorney to do it, which is fine. It's okay to do this, although a lot of these templates will not be tailored specifically to your business. If you're a single member LLC, meaning it's just you, there's no one else, you don't have to get too worked up or worried about this, as there won't be issues that are common when there are multiple business partners. So if you need to make a hard decision for your business, you make it, right? There's no hammering out details or worrying about, what decision to make or whether this is, more valuable for the business or not. Like, you're the one that makes these decisions, so you don't really have to worry about that. Now, if you are not a single member LLC and you have multiple business partners, the operating agreement is crucial. This is crucial. So this agreement is essentially the constitution for your business. It lays out how the shares in the business are spread amongst the partners. How do people get paid? How is the company managed? Who manages it? Et cetera, right? The default provisions in the New York LLC law, basically, what that will do is the statute will fill in the gaps that your operating agreement didn't address. You might have an operating agreement, you might have downloaded it online, you may have even had an attorney draft one for you. Who knows, right? But any time that there is silence in the agreement around a specific aspect of the business, the default provisions will kick in. Now, there's numerous scenarios and situations that we could walk through to really spell out why the default provisions are wholly inadequate for the most part. I mean, they just fill in a baseline and hope that that's okay and hope that that works for your business. And most of the times, it really doesn't. So let's use an example. We'll talk about distributions. So a distribution is basically the way that owners of LLCs get paid. You typically don't take a salary, you get a distribution. I mean, these can be weekly, monthly, yearly, but that's how the owners will get paid from the company. If you have, let's say, 3 partners in a business and you have an operating agreement, and the operating agreement says distributions will be based on your ownership percentage in the company. So if there's 3 of you, you each presumably will have a 1/3 interest in the company. Your operating agreement will say that, and it will say that in the distribution section, so that when distributions are made by the company, 1/3, 1/3, 1/3, even shares will be distributed to the owners. Let's say that your operating agreement doesn't have that language in it. Here's where it gets fun, and I'm being sarcastic. So the default provision in the LLC law says that distributions are made based on contributions to the company. If each of you as business partners contributed the same amount, you're not really gonna have an issue, right? But what about that situation where there's 3 partners and 1 partner happened to contribute more because they had more to invest in the company? So for example, it's you and 2 other business partners. You and one of the partners contribute $100,000 each, and your 3rd business partner contributes $400,000. Well, per the default provisions, when it's time to make a distribution to the owners, it's not gonna go 1/3, 1/3, 1/3. It would actually be 16%, 16%, and 66%. Obviously, that is not the ideal set of circumstances. Using this one example, this can happen in so many different aspects of running your business when you're relying on the default provisions. The purpose of this video is really to encourage you to put in the effort to draft an operating agreement that really is aligned with the specifics of your business, how many partners you have, and what makes the most sense for the business that you're running. It's honestly, it's a cautionary tale to avoid these default provisions at all costs. You want to have complete control over how your business is run, and you certainly don't want the state of New York telling you how to run your business. That's it. That is why a solid operating agreement will save your business from the inadequate default provisions of the New York LLC law. If you liked this video, you want to see more, please like, subscribe, double tap, and I'll keep making them.